We have been very fortunate to have worked for the past several months with one of the premier estate planning firms in the country, based right here in San Diego. Our Michael Walters, or Mike to his many friends and clients, has given his expert legal advice on a number of broadcast venues. He is also a renowned speaker and has spoken to thousands at free workshops throughout California. We caught up with Mike at his office in Rancho Bernardo between speaking engagements, where he graciously shared with us the most common misconceptions when it comes to wills and trusts.
Thank you, Maya. It's always a pleasure to be on this show. I've been asked to talk today about common misconceptions about wills, trusts, estate planning, and so forth. It's really quite simple. There's only three possibilities. When you die, someone wants your stuff and someone needs your stuff. So how do they get that stuff? The first choice you have is to do nothing. If you do nothing, since dead people can't sign deeds, the court will have a special procedure. This proceeding is called probate. It takes about 2 years. During this period of time, your assets will be frozen. And at the end of the day, the state of California will decide who gets all your stuff. Now, the state of California has a set of rules. They're called the Rules of Intestate Succession. They're in the probate code. If I were to go through all those rules, I'd be here probably tomorrow at about this time, so I'm not going to do that. The second thing you could do is you could have a will. Now, when you have a will, it's still a court proceeding called probate. It still costs a lot of money and takes a lot of time, freezes the assets. But after that 2 years or so and spending a lot of money, you will decide who gets your stuff according to the terms of your will. Quite an improvement. The third possibility you have is a trust. With a trust, there is no court proceeding. Everything happens privately and secretly within your family, and you decide who gets all your stuff. As to the three possibilities, obviously I think having a trust is the best. It saves thousands of dollars and a great deal of time, and it's much easier on your family. But let's get back to that, the court deciding who gets your stuff. Let me give you an example of what can happen with that. We had a lady come in to see me a few years ago, and she and her husband had owned a home for many years, and they'd had a hard time financially. A friend of theirs sent them to a guy, I think in Mission Valley, who specialized in difficult refis, and this was it, last stop. Next stop, bankruptcy. So they brought all her stuff in, and the guy looked him up on his computer, and he leaned back in his chair and smiled and said, "I got good news for you. So you're not a difficult refi at all. The problem you're having is that the wife has had a terrible business failure, just awful. That's what's pulling your FICO score down." He said, "Here's what I can do. Let's just have the wife sign a deed over to her husband. Put the house in the husband's name alone. Drop out of all the wife's problems, eliminate the wife from the situation, and I'll get you a great deal." So that's just what they did. The wife signed a quitclaim deed in favor of her husband, putting the house in his name alone, and it worked. They got a great deal. They got a new loan, they paid off their business debts, their credit card debts, their cars. I mean, they reduced their monthly payments by about 50%. Unfortunately, just a few weeks after that, the husband, while playing golf, just dropped dead of a cerebral hemorrhage. The house was in his name alone and he had no will, so what happened? Well, the first thing that happens, he went through a probate. It cost about $30,000 and took 2 years. At the end of that 2 years, the house was distributed according to the rules of intestate succession. Who owns the house today? Well, the wife owns a third of the house, and her two sons, 8 and 10, own the other 2/3 of the house. Now, if the same couple had had a will, the husband had had a will, after a probate proceeding, the house would have gone to his wife. Still would have cost about 30 grand, but it would eventually go to his wife. If they'd had a trust, the house would have immediately gone to his wife with a stroke of a pen. Those are your three choices.